Okay, so we're back with the facts, and I'm just going to keep going. So defendant Tubingstein and the other individuals did not treat plaintiff Q. Stevens' burn in any way, only examined it. Then defendant Tubingstein ordered plaintiff K. Stevens to buy a list of supplies at the medical store and to administer 3 times daily wound care for plaintiff Q. Stevens' burn without medical instruction, supervision, or assistance at plaintiff K. and R. Stevens' home. Plaintiff K. Stevens and Plaintiff R. Stevens did as defendant Tubingstein ordered and did complicated bandage changes on Plaintiff Q. Stevens at their home several times a day without medical instruction, supervision, or assistance, which was horrible. On April 14th, 2007, Plaintiff K. Stevens called OHSU and spoke with Dr. David Salons and told him that she felt like she didn't know what she was doing, because I didn't. Dr. David Salons assured Plaintiff K. Stevens that she was doing everything adequately and that she should just keep doing what she was doing and not bring Kadira back to the hospital. On April 16, 2007, Plaintiff K. Stevens notified Hayhurst Elementary School about Plaintiff Q. Stevens' injury and the circumstances surrounding Plaintiff Q. Stevens' injury and that she would not be returning until she was healed. So, as you can see, a lot of mandatory reporters were contacted. In late April 2007, Beth Phipps, a claims adjuster for State Farm Insurance Company, visited Plaintiff K and R. Stevens' home and asked to take pictures of Plaintiff Q. Stevens' burn. Plaintiff K and R. Stevens were uncomfortable with this visit and decided to get legal representation for Plaintiff Q. Stevens to make sure that the situation was being handled appropriately. In early May 2007, Plaintiff K and R. Stevens retained Stephen P. Reidlinger of Suzak and Powell, PC, to represent Plaintiff Q. Stevens. On approximately May 18, 2007, Defendant Kocher contacted Plaintiff K. Stevens and convinced her that she needed a special burn attorney to represent Plaintiff Q. Stevens. After that conversation, Plaintiff K and R. Stevens decided to switch Plaintiff Q. Stevens' representation to the firm Evangelisti Kocher LLP. I still don't know where Scott got my number. Defendant Providence, Defendant OHSU, Defendant Portland Public Schools, Defendant Evangelisti Kocher, Defendant Lockenmeyer, and Defendant Stephen P. Reidlinger are all mandatory reporters and had a legal responsibility to report Plaintiff Q. Stevens' burn injury to the proper authorities. On August 16, 2007, Plaintiff R. Stevens filed his second charge of discrimination against Defendant Nike, claiming retaliation because Defendant Nike told... Because Defendant Nike told Plaintiff R. Stevens that he was being laid off because all NASCAR positions were being eliminated. Plaintiff R. Stevens' position was not specific to NASCAR. Plaintiff R. Stevens was an Exeter employee working on all aspects of the Exeter business. Plaintiff R. Stevens' last day at Defendant Nike's corporation was September 28, 2007. Plaintiff R. Stevens applied for multiple positions within and without Nike, but he could no longer get an interview or job of any kind in his industry. In October of 2007, Plaintiff R. and K. Stevens' youngest daughter was stricken with a rare, life-threatening autoimmune disorder called Kawasaki syndrome and hospitalized at Emmanuel Hospital for treatment. Plaintiff R. Stevens liquidated his 401k in order to COBRA his health insurance to cover Kamaya Stevens' hospital stay, treatment, and any further medical expenses that might arise out of her medical condition. On November 15th, Defendant Nike announced the sale of Starter Brand to Iconics. Defendant Nike guaranteed the loan of $60 million for Iconics, and Defendant Nike and Iconics agreed to indemnify each other in the event that anything went wrong with the deal. On November 17, 2007, Plaintiff R. Stevens filed his third charge of discrimination against Nike, claiming defamation because he could no longer get work in his industry. Excuse me. That's a lot to read. On November 17, 2007, Defendant Kocher contacted Plaintiff K. Stevens and told her that Plaintiff Q. Stevens needed a guardian ad litem and that Plaintiff K. Stevens had to be her guardian ad litem in order to move forward on behalf of Kadira. Defendant Evangelisti Kocher had a trained guardian ad litem on the payroll by the name of Patricia Piazza, but did not inform Plaintiff K and R. Stevens that they had any other options. On November 21, 2007, Defendant Kocher petitioned to have Plaintiff K. Stevens appointed the guardian ad litem for Plaintiff Q. Stevens, which was granted by Defendant Dale R. Koch. Defendant Kocher filed suit against Defendant McQuiston in Multnomah County Circuit Court. Defendant Rudy Lockenmeyer appeared as counsel for Defendant McQuiston to help Evangelisti Kocher cover up the abuse and neglect of Kadira Stevens. I want to stop you there because I was never supposed to be appointed Kadira's guardian ad litem.
She was an abuse victim.
She was an abuse victim.
Federal law dictates that in matters of abuse, guardian ad litems are supposed to be either trained child advocates or attorneys. So, and they knew this.
They knew this.
Scott knew that. Richard Vangelisti knew that. And Judge Michael McShane knew that.
Right.
So did Rudy Lockenmeyer.
Right.
They
So
all
they were
knew
just
that.
they were just lying.
They were all lying to help cover up for Todd and Rex.
Okay, so we're gonna stop right there, and we'll get back to more of the facts in the next episode.
Thanks.
Thanks.